All right, good evening. We're going to go ahead and start the charter amendment question and answer forum here on February 28th, 2019 at 6 p.m. Well, 6:18 p.m. My name is Jonathan Evans. I'm the city manager here in the city of Madeira Beach. I have the city attorney, Mr. Ralph Brooks, and our city clerk, Ms. Clara Lamb-Blargan. And we have our Charter Review Committee Chair, Ms. Doreen Moore, that's here with us on the dais. Before we get into the questions, I think it's important for the public to know the process that the agency had to undertake for the purposes of going through a charter amendment and a review process, that it is not something that is initiated by the staff or the Board of Commissioners, that there is a citizen group that is appointed by the Board of Commissioners to go through the municipal charter, which, as it was stated earlier, is the organization's constitution. In order for the charter to be amended, it must be amended by a vote of the voters. It is a contract between the voters, the residents, and their government entity. And so I would like the Charter Review Committee Chair to share a little bit with regards to the process that the committee went through, because they did some exceptional work in trying to modernize the charter and address some of the things that there was some conflicting language, and providing a little bit more clarity to the way in which the charter reads and bringing it to the 21st century. So without further ado, Ms. Doreen Moore.
Thank you. I had gone back earlier today and pulled out some of my notes, and fortunately I found the frequently asked questions that were put forward when we were doing the charter amendment review and vote in November. And it outlined, as you mentioned, that we had a charter review committee that was made up of a group of citizens that were tasked with reviewing the charter and the proposed changes. The members were appointed by the Board of Commissioners, and obviously we had volunteers from the community. Then we had a series of meetings. What this question and answer sheet outlined the history. We started in July of 2017. So we met, it looks like about, I want to say, I'm not going to count them all up, but it was pretty close to a dozen times throughout 17 and into 18, and then continued after the November vote that we had at the first series and go-round. And so that's pretty much how we came about. We went through item by item. We looked at what was there. We looked at how things had changed. You know, the charter was written over 50 years ago, approximately 50 years ago, and yes, some of the changes were simply earlier on gender neutrality and things like that, but all things change, and certainly with the advent of social media and different mechanisms on how things are handled, it was an opportunity for this diverse group of residents to come together. And we didn't always agree on every single item, but it was the majority rule of why we would make these recommendations, and through our staff and city attorney attempted to make every effort to make them explainable as anyone other than an attorney can try to make something sound good that's dry. So without further ado, I guess that's as much of an explanation.
One of the things that I think is important for the folks in the audience as well as those at home, understanding the importance of making sure that you're informed and educated on the issues. Certainly watching this session will provide some clarity, but in the event that you still need additional information, please do not hesitate to contact the city clerk's office. The city attorney has also provided on our website a layperson's interpretations of the charter amendment, but we do want to make sure that you're informed as you go to vote on March 12th, or if you're filling out a mail-in ballot and mailing that in. So one of the things that we will do is the city attorney will, or the city clerk will actually read the question, and the city attorney will provide some explanation on the issue, what a yes vote means, what a no vote means, and then we will go through that. In the event that you have any questions as it relates to any of the charter amendments, we ask that you hold those questions to the conclusion of the actual presentation, and then we can go back specifically and address those questions that you may have. Also, if there's any clarification with respect to why the Charter Review Committee felt certain ways about certain items, that is something that they are prepared to entertain and provide some clarity to. But I can tell you from the couple of meetings I was able to attend, they certainly viewed it from multiple perspectives and looked at ways to improve the document as we work through it. So again, we will have the city clerk read the item, and then the city attorney will provide some explanation as to the item itself.
Okay. The first charter amendment is regarding simple majority vote. This charter amendment would require a simple majority vote of a quorum of commissioners present and eligible to vote, instead of 3 affirmative votes for most actions of the Board of Commissioners, including ordinances, resolutions, and other routine actions of the board.
So if you look at your packet, it's helpful to look at the second part of the packet. In the second part of the packet, you'll find the ordinance, and then it'll have the ballot question, and then below that ballot question, it'll have the underlining and strike-through language from the existing charter. That way you can see how the existing charter is being changed by the proposed amendment. This particular amendment would change the votes that are required unless otherwise expressly provided by the charter. So there are some sections in the charter that specifically say how many votes are needed for a certain item. But otherwise, the existing charter required 3 affirmative votes for passage. So that seems like a simple majority. If all 5 are here, then you would just need 3 out of 5 to pass something. But for example, we had a special meeting earlier this week, and there was an item that was on the agenda, and it came up for a vote, and the vote was 2-1. So under the existing charter, you need to have 3 votes. Therefore, the 2-1 motion failed. This charter amendment would change it to be a simple majority of the quorum that's present. So if only 3 people at our particular meeting, 2-1 would pass. 2 votes out of 3 would pass as a simple majority. So that's what this is attempting to address. Are there any questions about number 1 or comments?
I was just going to suggest, you said hold it to the end, but it almost seems like with such a small group, it might be better to take the question and then ask the question as it pertains to that particular item.
Yeah, that's certainly fine. We can do that. And if you can state your name and your address for the record.
Bill Mons. Okay. Bill Mons, 13321 Boca Ciega Avenue. Just a quick question. In the example that you just used, there were 3 commissioners or 2 commissioners plus the mayor, whatever. So there were a total of 3. That qualifies as a quorum?
3 is a quorum. A quorum is separate from this question. This is about what's a majority vote. But if you have a majority of the board there, including the mayor, 3 out of 5, that's a quorum and you can have a meeting. But to have a majority vote, they needed all 3 to vote yes for every single item that came before them, and some things did not get all 3 votes. Therefore, some things failed.
So if there were 2 present, that would not have been a quorum, therefore they could not have voted at all.
That's correct.
Okay.
This doesn't change that. Doesn't change the requirement of quorum.
Thank you. Tom Edwards, protected address. I don't have a problem with the wording except for one word. I don't see where if you have only 3 and you come 2-1 vote for resolutions or routine actions, maybe some expenditures, I have a problem with that. But for passing an ordinance with a slow majority of only 2 seems like a low threshold. I was wondering if Doreen could explain a little bit more why they chose that for ordinances and didn't exclude that particular part.
We do have, from the last round of charter amendments, ordinances that are rezonings for planned development, for example. Those require four affirmative votes. So we put a supermajority in for those. But for other ordinances and routine actions, this would be similar to most other cities and counties, in that you just need a simple majority of the quorum that's there to vote under the proposed thing. Doreen, do you have any further
I
insight?
think that there was also discussion, and I realize that this is not set in stone in terms of a charter, the verbiage in the charter itself, but the discussion was had that if it were something that were out of the ordinary and the item to be put before the commission, that the mayor or the commissioners could defer or ask that it be, what's the word I'm looking for? Put off until the next meeting. So if there was something that were of a greater, rather than just the day-to-day business or the financial,
Right. And the other thing, the other fail-safe measure that's in place with respect to an ordinance is it requires 2 readings. So in the event that it comes before the board and there is only 3 members that are there and 2 vote in favor, it still has to come back to the board at the next regular meeting. And at that time, you should have a full quorum to be able to handle the item. But there is also still a chance that you still have 3 members that are there and the 2 members vote in favor of it. But with an ordinance, you do have that second reading that's required to pass. So you have a little bit of an opportunity as a fail-safe measure.
Steve Kojic, 15301 2nd Street East, Madeira Beach. In Section 7.3, how is that going to affect it? Section E, the majority of the members, Board of Commissioners constitute a quorum. The affirmative vote of the majority of the quorum present shall be necessary to enact an ordinance or adopt any resolution, provided that 2/3 of the membership of the board is required to enact an emergency ordinance. On final passage, the vote of each member of the Board of Commissioners shall be entered on the official record of the meeting.
Emergency ordinances would be, unless otherwise expressly provided. Florida statutes allows emergency ordinances to be adopted with just 1 reading. You don't have to go through 2 readings, but it has to be declared an actual emergency. You can't just use that for routine matters. It has to be a hurricane or impending disaster or state of emergency, something that's coming up that affects the whole health, safety, and welfare of the city. So that's dealing with only with emergency ordinances do require 2/3. Now, once you adopt an emergency ordinance, then you have to go through the regular ordinance adoption process after it's adopted. So those are to take care of instances when something has to be done within a week, not within a month or 2.
And in those particular cases, like the city attorney said, it's a state of emergency that's declared usually by the governor of Pinellas County and then the city. So those are not situations whereby the city manager can come to the board and say, this is an item that we need to, move forward with, unless it is something that jeopardizes the health, safety, and welfare of the public. But you won't see a situation where it's utilized more so on a local issue that it's impacting only Madeira Beach. So those are usually the steps that you would see that, and that's usually for disaster preparedness to be able to get, equipment or assets here to address whatever the issue may be.
One example is the emergency curfew ordinance that we would adopt if there was a hurricane or post-disaster hurricane scenario. You're welcome. Do you want to read the second one?
Charter Amendment Number 2, term limits. The charter amendment would amend the charter to establish new consecutive terms limits. The mayor and district commissioners shall serve no more than 3 consecutive regular terms and shall not thereafter seek re-election for a period of 2 years for either mayor or district commissioner.
So this was a political issue, I guess. Many cities, counties are adopting term limits. And I guess the public policy is to turn over council members every so often. This term limit is relatively long. It's 3 consecutive regular terms. There was some discussion about if a commissioner was appointed midway through a term to replace someone that resigned or was removed, that would not be considered a regular term. So they would get that plus 3 consecutive regular terms. And then, of course, this language allows the commissioner to take a 2-year break and then to run again. So it's similar to some counties and cities. Some counties have 2-year terms, two-term limits. This is a 3-term limit.
And this is not retroactive, it's prospectively, correct?
Yes.
Lori Stem, 209 140th Avenue. What is it now? What are the limits now?
There are no limits right now. You can run as many times and sit for as long as you want. You could be an 80-year commissioner if you live that long.
Steve Kochik, 15301 2nd Street East. I'd have to advise the people to go against this. The term limit is already set in my idea as when you go and you elect someone. If they want them out, and in Madeira Beach we see this very frequently. They don't want them, they're out, you know, and then come back. This is something I can see for state where you really have, you know, it's a little bit different. But for the city, we have such a difficult time even finding people to run that if somebody's doing a good job and you're going to throw them out just because of a term limit, I would hope that the people vote this no. Thank you.
Number 3.
Charter Amendment number 3, forfeiture of office for knowing violations of certain state laws. This charter amendment would provide that a commissioner shall forfeit office if the commissioner is found to have knowingly violated the Sunshine Laws, ethics laws, or public records laws by Florida Ethics Commission or a court of competent jurisdiction. A special magistrate shall make the final decision concerning forfeiture of office if a commissioner requests a forfeiture hearing.
So if we look at page 4 of 15 at ballot question number 3, you'll see a whole section is stricken, and then a new paragraph is substituted. Some of it remains the same. The main idea here is that we were establishing a process for forfeiture, and we wanted to remove politics from the forfeiture as much as possible. So instead of the Board of Commissioners voting on their own members to kick off a member of their own commission, they would refer the matter to a special magistrate who's typically trained in the law, usually a lawyer or a retired judge, or has some training, is independent, is not elected, and it's not one of the commissioners themselves who are voting. So a commissioner could make a motion and receive a second and refer another commissioner to a special magistrate to see if they have knowingly, not unknowingly, but knowingly violated either Sunshine Law, ethics law, or public records law. There was a lot of debate on the Charter Review Commission that it should be knowingly so that you wouldn't be subject to inadvertent violations, violations that you did not knowingly undertake. And so that was placed in there too. I think there was some discussion and worry that people would try to trap people into violations of Sunshine Law or ethics law or public records law. And sometimes the commissioners might even act on the advice, maybe even improper advice of staff or a city attorney or a city manager. And that has happened in the past where a city attorney had said it's okay to vote on something in a certain way. They voted, it turned out no, it was in violation of the Sunshine Law. The commissioners themselves didn't knowingly violate the Sunshine Law, they were taking the advice of the city attorney. So under that scenario, The special magistrate would hear all the evidence and determine whether there was a knowing violation or not. And if there was a knowing violation, then that would be sufficient grounds for forfeiture or losing your office or removal from the city commission. Yes.
Tom Edwards, protected address. The city has a special magistrate that they use for code enforcement. You wouldn't be bound by using that person. You could bring another attorney and appoint him as a special magistrate to handle these type of actions. Is that correct?
That's correct. It would all be done in the Code of Ordinances and appointment, perhaps by resolution, it could be the same one or it could be a different one. You don't have to use the same person to be special magistrate for variances, special magistrate for code enforcement, and special magistrate for forfeiture. It could be the same person, but it does not have to be. But the charter would simply require that it goes to an appointed special master rather than to the city commission itself voting on their own members, which they thought would be politically improper. People would vote based on politics instead of based on the facts and the law that was presented to them. A danger that could happen.
City Attorney, I have a question related to that item, and this may be something that we should consider clearing up in an ordinance, prescribing the exact process, how that magistrate will be selected. I think that's important, so it's not something where the city manager goes out and selects. I think it's something that, whether it's the Board of Commissioners has a list of 3 names and conducts an interview or what have you, we probably should prescribe in some type of form and fashion in the event, and hopefully we never get to that point, how it's done, so it's done consistent with whatever the prescribed policy is, versus if something happens, we're trying to find a way to get from point A to point B. And we
That's
just
a
want
good point. The charter is more general, like a constitution, and then the Code of Ordinances can be more specific, like regulations or procedures for RFQs, for selection, whether we select one ahead of time that's always available or whether we wait until the issue arises. All those matters can be discussed. If this does pass, then we can fill in more detail.
Steve Kochik, 15301 2nd Street, East Madeira Beach. This is something that, once again, it's something that I feel is very dangerous. We have people that are elected by the people, and we've seen it recently, where litigation can come from anywhere for any reason. And once again, what we get mired in is that city official, plus the city is going to have to pay for any legal fees if it's during the course of their duties. I would assume that that's correct. But once we start to open it up to where you can just bring anything that you think is a sunshine law, ethics law, we start to get involved with that. I don't see where the necessity was to go from the way that we used to do things into something like this. This just seems to me, it's a way that if someone doesn't like a board member, they can entrap them, and then we got a problem. We're going down a really shaky road when we start to look at removing people that people have elected, and it's a 2-year election.
So the commission did consider that, and one of the things they put in there was that it would have to be a finding first by the Florida Elections Commission or a court of competent jurisdiction. So if a citizen thought that there was a violation, they would have to make a complaint to Florida Elections Commission or go to a court of competent jurisdiction or say go to the district attorney for a criminal violation of sunshine law. So it wouldn't be really conducted here first. But say the Commission on Ethics found a knowing violation but did not recommend removal of office, only recommended a fine. If this charter amendment passes and there was a knowing violation in the Commission on Ethics order, then that would be grounds for forfeiture, and it would be referred to a special magistrate unless the commissioner chose to resign rather than request a hearing before the special magistrate. So there's a couple layers of due process here before they're actually removed from this particular dais. They have to go through the Commission on Ethics process, which is pretty complicated and long, or through a court proceeding.
And I think that as a committee, that was exactly what we were attempting to do. The reverse of what you're saying, Mr. Kochek, is that we were attempting to make this an arm's length situation, that a resident or another commissioner who has a dislike or a problem with someone else seated in office, that they can't make the allegation and expect that this administration or this commission is ruling against itself. So someone who has a problem with a person and feels that they have done something, whether it's ethics, sunshine laws, or public record laws violation, it has to be found to have had merit, and then it goes to the special magistrate if it met that criteria. So we feel we were making it arm's length.
Charter Amendment number 4, forfeiture of office after 3 unexcused absences. This charter amendment would provide that a commissioner shall forfeit office if the commissioner fails to attend 3 instead of 4 consecutive regular meetings or regular workshop meetings without being excused by the Board of Commissioners.
So currently, a commissioner would forfeit their office if they miss 4 regular meetings without being excused. This would change it to 3 consecutive regular meetings or regular workshop meetings without being excused. So instead of 4, it's going down to 3, and they're also including the workshops as well as the meetings. We typically have 1 regular meeting and 1 regular workshop per month. And we do have special meetings that are called sometimes on very short notice, and it's hard for everyone to be there. So the commission decided to leave it regular meetings and regular workshops, so that everyone can understand the schedule ahead of time, and it would be fair to have 3 instead of 4. And again, this is without excuse. So if someone is in the hospital or is called for active military service or some other reason that would be good cause, and it's excused, then those meetings would not count as an unexcused absence.
Steve Kochek, 15, you know who I am. Yeah, I'm tired of saying that. Now that you've explained it, I think that helps me accept it a lot more, that it would be 3 months still. Or are you taking in, does it have to be 3 meetings, like a regular meeting, a workshop, and a regular meeting?
That's it, yeah, so it could
Okay.
be a month and a half, really, a regular, a workshop, and a regular.
And
Or actually, it could be 1 month, I guess, almost, just 1 month.
it could be,
Yeah.
it could be 1 week?
Well,
Somebody,
the regulars are once a month.
Okay. so they're defined as used to be defined 1 regular meeting a month, and we used to have only 1 workshop a month. Now we're having meetings every day, it seems like. So those don't count. The ones that are called special meetings or mayor's prerogative meetings, whatever, those aren't counting.
Those are not counted.
I think the thing that we leave out, there was a time when it was just accepted that, if somebody gave a thing, it would be an accepted excuse. Today, with some of the differences that we have between the groups in Madeira Beach, that we're going to have to define what's an acceptable reason for missing a meeting. Because I could see it with the present board, that if Nancy Hodges misses 3 meetings, she's gone. Because they didn't accept her reason for being there, whatever it was. It's just not acceptable. We don't have a clear definition of what's an excusable. In the past, there was a reasonable gentlemanliness and womanliness, let's say, to keep the 2 genders going, of fairness, that if somebody missed a meeting, there was a reason for it. They went away on vacation. They did this or that, and it was accepted. Now it might be a little iffy, and there is no definition, so they could make their own term. And I would hate to see that. Once again,
One of the things we can consider, Mr. Attorney, in the event that this passes, is when we do bring back the charter or the actual policy manual for the Board of Commissioners, it documents exactly their how they conduct themselves up here on the dais and how they call meetings and what have you, we can specify exactly the process that they would have to go about to have an excused absence. So whether it's notification to the clerk within 24 hours or something like that, we should be able to do that. And then once the board adopts that, that will be the background behind that to that point.
Number 5? Oh,
Charter
there's
amendment.
one more question on 4,
Okay.
sorry. Didn't see.
Jerry Clyett, 14040 Marguerite Drive, Madeira Beach. I interpret the excused absence to mean that you called in and you just said, I'm sick today, I can't come in. It's not graded. No, I don't think anyone says, yo, wait a minute, your dog's sick, no, it doesn't count. I mean, the excuse comes in the fact that you called in and you let them know you're not going to be there. Is that correct?
I can't recall a recent meeting where someone who was absent and requested to be excused for a good cause was turned down.
I can't think of one.
We haven't had a situation like that, but we don't have anything prescribed in the policy that says what is an excuse, when is it unexcused. So it could be something as simplistic as notification to the clerk within, 10 hours or 5 hours or 8 hours of the meeting is considered an excused absence by the Board of Commissioners, and the clerk will inform the board at the meeting that ex-commissioner is not going to be in attendance, but we just don't have anything in writing.
Charter amendment number 5, adjustment of district boundaries every 5 years. This charter amendment would require that the Board of Commissioners shall review and, if necessary, change the existing municipal district boundaries to ensure that each district shall be approximately equal in number of electors every 5 years instead of every 4 years required in the current charter.
This particular amendment, I think, generated from discussion about the census and how often it was done and being done every 5 years, and to make sure that it was actually done. We have some development going on, and the development may impact the amount of people and population in various districts. So we thought, the commission thought that every 5 years would be better than every 4 years. But was adamant that we should retain this in the charter. So that's what this one is about. You can hit the next one, number 6. Oh, there was one question. Hold on.
Just a quick one. Was there a consensus on the committee or within the commission that somehow 4 was not enough? Is that it?
No,
It
4.
was too frequent.
It didn't. It was weird because it didn't match up with the census, so we wouldn't have the actual population data. We get the population data every 5 years, so we thought when we get that, then we do it.
Charter amendment number 6, adopt state law for recall procedures. This charter amendment would cross-reference procedures for the recall of elected officials in Florida statute section 100.361, municipal recall, because the city charter is currently silent regarding procedures for recall.
This cross-reference to the statutes was recommended by the Charter Review Commission, in part because we did have some recall issues last year, and there were so many calls into the clerk's office, people couldn't find where the recall was listed in the code and in the charter, and it really isn't. It's listed in the statutes. So this is more or less a signpost for people to see and then know where to go to read the procedures about how to conduct a recall. It doesn't change state law or add to it, but it does let people know where they should go read to find out about a recall. Number 7.
Charter amendment number 7, induction of newly elected commissioners. This charter amendment would require the induction of new Board of Commissioners and appointment of a vice mayor at the first regular or special meeting, which shall be held on or before the last day of the month in which the election was held. Rules of board procedures shall be adopted within 90 days following each election.
So maybe the clerk can help us with this one a little bit. The Charter Review Commission thought that it would be a good idea if we had an election, say in March or November, that we install the new commissioners in March or November rather than waiting for April or December. Correct. And so this would expedite, if you will, their taking their position and beginning their new role.
Correct, and also currently, our regular meeting is the second Tuesday of each month, which in March, the second Tuesday is our election, so they moved the regular meeting to the third week. And so for this one, we put for the induction to be on March the 19th.
Question 8.
Charter Amendment Number 8. Recognize city manager and remove city treasurer on the list of charter officers. This charter amendment would recognize the city manager as an existing charter officer and remove the city treasurer/finance director from the list of charter officers that are hired and fired by the Board of Commissioners, thereby placing the authority to hire and fire the city treasurer/finance director directly under the authority of the city manager, and place the city treasurer/finance director under the direct supervision of the city manager by ordinance.
So this charter amendment, if you look at page 9 of 15, it's explanatory here to look at the underlining and strike through. We're adding city manager, which was somehow left out of section 6.1, even though he's mentioned elsewhere in the charter, to the list of charter officers, and striking and removing the city treasurer, who shall also serve as the director of finance or finance director under the existing charter. So under the existing charter, the city treasurer or finance director is hired and fired directly by the city commission. Under the proposed charter amendment, the city finance director and city treasurer will be placed under the city manager and the organizational structure. So to be hired and fired by the city manager rather than by the city commission directly.
Helen Price, 13319 Boca Ciega Avenue, here in the beautiful city of Madeira Beach, Florida. I was just thinking when I read this, I think maybe the original reason to have the city treasurer not under the city manager, there was some sort of division of power issue, and now we're putting it, now we don't have that. What's the rationale, I guess, of making the city treasurer not a charter officer?
I think it's a political decision again, but there was some discussion at the Charter Review Commission about trying to streamline the organization. But there's pros and cons of both things. You raise a good point that the city treasurer, finance director, if he is a charter officer appointed by the commission, is a check and balance, if you will, on the city manager. A con is that there's only one budget, and if the city manager and the city finance director disagree about a budget, it's difficult to prepare and present. But then again, the city commission does make the final decisions on the budget as well. There are some employees that are under the finance director, but that are hired and fired by the city manager. So it makes it difficult for certain positions to serve two masters, to have two bosses, if you will, especially if they disagree about something. It's not that often that they disagree, but it's possible that they disagree. And so one of the pros is that you have one person at the top of the organizational chart rather than two people, with regard to city finances and city budgets and those type of financial decisions.
Does the fact that we're taking the city manager now and making that position a charter officer, does that in any way affect the contract relationship? I mean, now we have one charter officer that has a contract and the other charter officers don't. I mean,
Well,
does that have any impact?
Right now, the city manager is a charter officer in a different section of the charter, so just recognizing that he's already in the charter. He has a contract with the city commission. The city clerk also has a contract with the city commission directly. The city clerk is hired and fired directly by the city commissioners, not by the city manager. And then the city attorney, of course, also has a contract with the city commissioner and is now hired and fired by the city manager, is hired and fired only by the city commission. So right now, the city finance director treasurer is a charter officer to be hired and fired by the city commission. But if this were to be adopted, that would change, and city finance directors would be hired and fired by the city manager and selected by the city manager. So it is a choice there. It's something to weigh and consider when you look at this question.
So I guess the definition of a charter officer is someone who can be terminated by the Board of Commission? Is that fair?
Charter officer is a position or office that's named directly in the charter. And you could have, things set up slightly differently, like currently there is a provision in here that's a little bit complicated, or a hybrid of how a city treasurer or director of finance is to be appointed. This would remove that ambiguity as well. So city manager, city clerk, city attorney would all be hired and fired directly by the city commission. All the other employees would be hired and fired by the city manager, including the finance director.
Can I comment on that too?
Yes.
Looking at the existing charter, there's confusion in the way the existing city charter was written.
I agree.
It says that the director of finance, who shall also be the city treasurer, the director of finance shall be appointed by the city manager, subject to the Board of Commissioners' approval, okay? So when we were going through that in detail, you have a charter officer that's this quasi-employee. Who do they report to? Where's the chain of command? How do you have a flow of personnel? As the city attorney pointed out, you have people who work under the finance director. They can't serve two masters. So by blending this together, the city manager is a charter officer, but we're recommending removing the finance director as being separately hired and fired by the Board of Commissioners and having it flow under the personnel as the city manager is directed to do with all other staff.
And to build on that point, when we looked at the language with respect to the appointment of the finance director, it takes the confirmation of the Board of Commissioners. There's no mention in the charter in the event that the finance director was to be terminated. Is it something that the city manager brings back a recommendation to the Board of Commissioners to effectively displace the finance director? So it was really nebulous in the language. In addition to, there's duties and responsibilities that are articulated for the finance director that are in direct conflict or the exact same duties and responsibilities of the city manager. So when we looked at that, we looked at an opportunity to really clean it up, and there's no other department director that is mentioned in the charter, so it's just having it consistent with the peers in the organization. It doesn't single out one department director versus another.
Okay. So charter officer is just a term of art used in this particular charter. There's no definition of one, right? I mean, because now we have a city manager, a city clerk, and a city attorney that are our charter officers. And they all three have contracts? Is that the
Yes, that's typical of most
vision,
cities.
or I guess, between a charter officer and just someone who's
Well, it's not a contract, it's like who has the decision to hire and fire. Most all the employees have actual contracts also, but the city manager hires and fires most employees. Only charter officers can only be hired and fired, and are chosen, if you will, by the Board of Commissioners.
Employees all have contracts?
The only employees that have contracts are firefighters.
Oh, okay, okay.
Yeah, but the rest are general employees, your regular general employees.
Thank you.
Just Steve Kochik, 15301 Second Street East. Just in the charter now, I think as you read it, it's the finance director, the city treasurer, the finance director is hired by the city manager with the approval of the board. That's going to stay basically the same, are you saying?
No, that would come out. It says the director of finance shall be appointed by the city manager, subject to the Board of Commissioners' approval. That language was ambiguous or nebulous, as the city manager pointed out, so it's hard to tell exactly what that meant.
It meant that
But that's gonna
he'd have a finance director and the Board of Commissioners would approve the hiring or disapprove for whatever reason.
It sounded like it would be a recommendation, like you say, like the city manager would appoint, which is kind of like, I'm going to appoint you, but you have to go before the board. It might be like the governor appoints someone to the Water Management District Board, or the president appoints someone, but it's subject to Senate confirmation. Right. You could appoint someone, but it's subject to the Board of Commissioners confirmation.
Having seen this happen in the past, what usually happened was the city manager presented to the board all the accreditations that the person has, experience, and said, now we have somebody that I think is going to be an asset for the community. And the board would look it over, and I've never heard them say no. It was just the approval, the official approval, because the board does have to make final approval on things. But it was always left to what I'm trying to get at,
That's
I don't
probably
want,
how it would
I don't
still
want
work
the
that
power
way
of
if
the
this
city
fails.
manager to be taken away by the board, even though the board could have voted no at any time and say, no, we don't want this guy.
Right.
But it would have been a good reason for it.
If the voters turn this down, that's probably how it would
Right.
still work.
And one of the other concerns we have with respect to the language in there is that in the event that the finance director is confirmed by the board and there is an opportunity to blur the line with respect to elected officials interfering with the day-to-day operations if they believe that the finance director, in fact, reports to them. So those were some of the things that we discussed as part of providing some clarification associated with it.
Okay. One last question on that. No. Thank you.
There's one in the back.
Thank you. Tom Edwards, protected address. It might help clarify as to if, and maybe you don't know, how many cities in Pinellas County follow the same procedure that you're proposing. In other words, having the treasurer, finance director under the city manager versus being separate and reporting directly to the city commissioners. I don't know, given the number of communities that we have in there, if you've looked at that and seen how many that might help people to understand it.
From my experience in the organizations I've worked for and the organizations I've researched, it's not a common situation. Usually you find provisions like this that have hung around in charters as organizations haven't amended charters over a series of time. Usually when you find these situations, it's in county government, knowing the process that when I was an assistant county administrator in Sarasota County, I was appointed by the county administrator and then confirmed by the Board of Commissioners, because it was an understanding that in the event of the absence of the county administrator, one of the three assistant county administrators would have to serve in that capacity. So the board needed to be, in essence, comfortable with that leadership team. But in most municipalities, you don't find where the finance director is a charter officer. They most likely, in most cases, report to the city manager. So it's probably something that's just been left over as we've looked at the charter or haven't looked at the charter for lack, for whatever reason.
Steve Kochik, one last question, I apologize. The city manager's contract and reasons for dismissal are going to continue to stay the same in the charter? There won't be any changes to that?
That's correct.
Yes?
Yep,
I
there's
think
no,
that we actually changed the city manager around a little bit last round of charter amendments that passed. So that's already been decided and voted on, and they did make some changes. But I don't know that it affected the contract per se. It was
Sorry.
more about process, hiring qualifications.
Yeah, I know they had
Yeah.
to be a city a part of an organization.
Yeah.
But there's no changes to as far as the procedure where the hiring and firing, as far as severances, pays, the whole contract negotiations type of thing, that's staying intact.
Correct.
To protect the city manager.
correct.
I always felt that's what that was for. Okay, thank you.
Number 9.
Charter Amendment Number 9, Delegation of Commission Investigation Procedures. This charter amendment would amend the section of the charter concerning investigations by the Board of Commissioners to delegate investigations into the internal affairs of the city by appointing a charter officer to investigate internal affairs of the city.
This particular question, it's helpful to look at what the existing situation is. Right now, it was the Board of County Commissioners would conduct an investigation, which is very hard to do as a collegial body of 5 people with the Sunshine Law restraints. They can't talk to each other except at a publicly noticed meeting. In fact, what happens more typically, I think, is that if there is some internal investigation, someone is appointed to lead it, whether it's employment discrimination or whether it's some other potential internal audit or other investigation of internal affairs would then be handled by another charter officer. So if the city manager were to be investigated, the city attorney or the city clerk could be appointed to lead the investigation. If it was the city clerk, the city manager might lead the investigation or delegate people. It creates checks and balances and says exactly who the commission would turn to organize and run and conduct the internal investigation.
Why did we take out the fine for not appearing for a subpoena?
I think that the Charter Review Commission looked at that and thought that these things were available under state law. It was unnecessary language to give the investigator these fines and imprisonment of 60 days. But that is taken out. They did not want to have that in there. They wanted to keep it more general for the charter language, and if they wanted to put more into an ordinance or into the code later to have more detail. But in this particular question, they wanted to stay as general as possible, like a Constitution section, as opposed to the detail you'd find in an ordinance.
So
later in an ordinance, we can certainly put these back in or make modifications or determine how subpoenas might be issued or how people would be called to testify before the investigator and whether they'd be under oath. All those could be addressed in an ordinance. It becomes a bit unwieldy if you try to put enough detail into the charter.
well, yeah, I mean, it takes words out, but okay. So does the city manager have the ability to issue a subpoena?
Not typically.
What about the city clerk?
Not typically.
What about you?
Not typically. I can issue
So-
as a lawyer, but not as a city attorney.
There has to be a lawsuit,
Code enforcement, I think we can issue subpoenas. Certain
but they're not a
administrative
charter
search.
officer investigating this. You three are going to investigate everything, in other words. You're the only 3 charter officers we have, right?
Well, it's not us three.
Well,
but-
assuming the finance director gets dropped off pursuant to the, I mean, the intent here is now you 3 people are going to lead any investigation.
Well, it would be, the Board of Commissioners would
By your
appoint
own-
one of the 3,
Right.
not all 3, one of the 3.
Just to comment on that, I think the alternative of having the way it's written now, which says the Board of Commissioners may make investigations, and it doesn't define who's leading the charge, I think that that opens the door for, you know, more of a witch hunt, if you want to call it, amongst the city. Why would you want your Board of Commissioners, you know, chasing this kind of a scenario? And what right do they have to be calling for subpoenas and
No, I
witness
agree.
evidence
I
and things
agree,
like that?
agree
So,
with that, but I'm just wondering why we're limiting it to, why
Because-
don't we, if we have a issue in the city involving any of them, I don't want the other one investigating. I want someone from the outside to come in and
You
look
certainly
at it.
still could go to the state attorney's office, you could go to FDLE,
But it doesn't here.
you could go to FBI.
Limited to you
Those-
three people.
Those are all in state law and in federal law. Right now, with the current charter, the current charter would allow the Board of Commissioners to conduct investigations and subpoena citizens and subpoena employees to come before them for internal investigation affairs hearing. So it might be similar to some kind of congressional hearing where someone is brought forward, like Michael Cohen today is an interesting example. But some hearing like that where someone is subpoenaed to come and appear before the Board of Commissioners and testify under oath. The commission, Charter Review Commission, thought that that was unwieldy and too political and fraught with politics.
I agree, I know, I understand. That's exactly what
Yeah.
Ms. Moore just said. So I understand that.
Stuff, yeah.
But what I'm saying is, why are we limiting it to you three people?
but what would be the alternative, I guess, would be my question.
We bring in an independent investigator,
Well,
you know,
actually,
with
typically
knowledge of whatever the
Typically,
issue
that's what
is.
would happen.
That's
The
what
city
would occur.
An
manager would,
employment issue, you bring in an
Yeah.
independent employment guy. If it's, I mean, certainly we did the audit, we did that big investigation on the, you know.
typically, that's what
Saying.
happens. We bring in an objective, third-party independent, either auditor or a team of attorneys to investigate some sexual harassment claim. It wouldn't typically be done by one of us. To create separation, usually go outside and bring in an outside independent investigator, which is done through the auspices of the city manager's office or my office or the city clerk's office.
So if I thought there was something going on in the city that I wanted investigated, and I came to the city and say, hey, I think we need to investigate this. I understand this, and this happened. Can someone look into it? One of you three would be the ones to do it, right? Assuming you.
First you'd come
allow
up, say,
something.
for
You
example,
could say,
in-
no, go sit down, or.
First, you'd come up, for example, probably in public comment or at some city commission meeting. You'd have to get a motion, a second, and a approval of the majority to conduct an internal investigation. Then they would appoint perhaps a city manager, and then he would probably go look for qualifications and find someone qualified in that particular area to conduct the investigation and report back.
Okay. Well, if that happens, I'd be happy. But I don't want any investigations, which it appears to me, only charter officers may investigate the affairs of the city. I don't know why we would even limit it to that. That's all. That's just my comment. Thank you.
It's the Board of Commissioners may investigate by appointing a charter officer. It's not, a charter officer doesn't have the power to investigate on their own. The Board of Commissioners may make investigations under this charter provision. Number 10?
Charter Amendment Number 10, Special Magistrate to replace Board of Adjustment. This charter amendment would replace the Board of Adjustments with a special magistrate.
This charter amendment recognizes that we use a special magistrate instead of a Board of Adjustment. Number 11?
Charter Amendment Number 11, Citizens Initiative and Referendum Procedures. This charter amendment would allow citizens to circulate petitions to propose adoption, require reconsideration or repeal of ordinances by an initiative and referendum vote of full electorate where not preempted by state law with signatures of at least 10% rather than the current 25% of the total number of electors registered to vote in the last regular city election and authorize petition circulators to collect qualified signatures on petitions.
So this question came before the Charter Review Commission with regard to initiatives and referendums, and they were looking primarily at either 10% or the current 25% in terms of how many signatures you would have to collect on a petition. Initiative is proposing an ordinance to the city by the people directly. Perhaps the city commission doesn't want to adopt an ordinance. The people can bypass the city commission and go straight to a referendum and a vote. If they currently have 25% of the number of electors registered to vote in the last regular election, this would reduce the number to 10. In effect, it would make it easier to adopt an ordinance by initiative. Now, referendum is similar. It's the reverse side of the coin. You could require the city to reconsider any adopted ordinance and then repeal an ordinance by collecting 10% of the signatures on a petition. Now, it's important we also add in here, we're not preempted by state law. State law has some preemptions on initiative and referendum. Primarily, you're not allowed to have a initiative or referendum on any plan amendment, any comprehensive plan amendment, or any development order. So you can't do it for developments, and you can't do it for comprehensive plan amendments. But other types of ordinances, resolutions, could be repealed by initiative or referendum with 10% of the voters. There was also a clarification to talk about the petitioners committee and allowing them to designate persons known as circulators to obtain signatures on the petition form. That was to resolve some issues that had come up in the past about who was collecting signatures and whether they were authorized by the committee or designated by the committee or not, and whether they had the ability to do that and who would be authorized. So this way the committee that's the citizens committee that's collecting signatures would appoint circulators. So you'd have to be approved but on their list. You couldn't be a third party. And it wouldn't have to be someone on the petitioners committee himself or herself. It could be people that are members or working with the committee to collect signatures.
Tom Edwards, protected address. So if you had a group of citizens that did this initiative, is there a time period that the election has to occur within? So once they receive their 10% and they present it to the city clerk and then it's verified by the elections division, so is there a time period that it has to occur? And the second part of my question is how expensive are special elections? How expensive do they cost us? Are they $9,000, $10,000 or more to have a special election?
So to answer your question, I have to kind of break it in two parts. Initiatives and referendums that would change a charter, for example, those are controlled by state law, and state law says how many days you have to hold the election, and it says shall be at the next general or the next special if there's not a next general coming up. If it doesn't involve the charter itself, then there will be no requirement in state law that I found that would require an election within a certain period of time. So they may wait to the next general election to save money, or they could, if they wanted, hold a special election, but you do have to pay more money for that. I think the clerk has some numbers from our typical elections, how much they cost.
Okay, for the whole process would have to be done before the deadline of the ballot language to go to the supervisor of elections. If it's for the November ballot, there's a certain day that everything has to be completed for me to submit that for that ballot. If not, if it's past that deadline, they will not accept it, and then we can look at the regular city election that takes place the second Tuesday of March. And again, the there's a deadline for that as well, which is the second Friday of January. So if it comes in, completes a week after, then of course the ballot language is already to the press, because the military people get their ballots first. So there is a timeline as far as that. And then if it's something where it needs to call a special election within that time frame, the commission can do
How
that.
much? How much does it cost to run an election? I think his question was too.
It's between
Approximately.
about $4,000 and $5,000. Now, when we had yeah, it's about $4,800. We have charter amendments and of course, the commission districts on this ballot, and it was less than $5,000. And then we get a reimbursement based on stamp cost and all that, what actually had went out. And when we added, for the additional that we had to add when we had the recall election, that added about $2,000 to that, but we got reimbursed because we actually didn't have a recall election.
And the city contracts with the supervisor of elections to conduct our elections. And some of those timeframes are not in the charter, or some of them are not even in the state statutes. They're by policy and procedure, because they do have to have newspaper notices, they do have to print ballots, send out sample ballots. So all those get factored in by the supervisor of elections in setting the deadlines that she has for each election. Will have different deadlines.
Tom, your question, though, because we discussed this briefly before, and he raised a good question, and I think that you were asking about specific dates and requirements. So if we had the referendum and it was going to be put to vote, there's nothing that says that we have to hold a special election within a certain period of time, incurring the additional cost. If the resident initiative was passed and it was going to go on the ballot for a vote, we could then just wait for March or November. There's nothing that says that you have to hold a special election. That was, am I phrasing that correctly, Tom? That your concern was that having the initiative and, let's say you had several and suddenly you were having to have special election
know if there
costs.
was a specific time period. So if once the voter count had been certified, if you had to have a special election within 90 days or 120 days or whatever it might be on any particular item that might come up in here. 10% seems like a pretty low number. I know, like with changes in the state constitution, it's a pretty high level. And going from 25 to 10% seems pretty low. So that's what I was wondering, why this number was picked rather than 20% or something like that.
I think the chairman might be able to address it, but it would make it easier rather than harder. And the Florida legislature has been trying to make it harder rather than easier to put changes on the Florida Constitution. So I think that the Charter Review Commission wanted to make it easier to do initiative and referendum.
And looking at overall, 10% seemed to be, and I hear what you're saying, 10% of the state of Florida is infinitely different than 10% of the 3,300 approximate registered voters that we have. So it was based on what other communities were doing, 10% seemed to be the norm, and we were higher, and we were trying to make that easier. Those other changes that were put in here were because there had been a petition initiative that was correctly conducted and thrown out for a technicality, and we wanted to clarify it because in reading the charter it was ambiguous, and that's why we wanted to get it cleaned up and try to make it as clear as possible so that an initiative could be properly conducted in the future if needed. So
10% certified signatures is just to get it on the ballot. Then once it gets on the ballot, you have to get over 50% for the initiative or referendum to actually pass the voters. So it would just be to place it on a ballot to get it to a vote of everyone.
The petitioners committee is it just kind of pops out there. So I'm a disgruntled voter, and I don't like something, and I'm going to go get my uniform pieces of paper and go to my neighbors, and they're going to sign the petition. I have to form a committee.
You can be a
do that?
one-person committee if you want to. You have to come into the clerk's office, and she has papers that we register, put your name and your...
So I have to go to the city and ask permission and give you the names of people that are going to help me get signatures against something I don't like the city is doing?
No, you do not have to ask for permission. You just have to go to the city and fill out the form that you are forming a petitioners committee, and you will be going out to collect signatures, and these are approved. These are the people that are going to be collecting signatures for you, the circular.
Why do I have to tell you anything? Why do I have to tell the city anything? I don't want the city, I mean, I just may want, why do I have to go, if I'm going to get a referendum going, it's because I think the city's doing something wrong or whatever, I don't know, or I want a law changed. Why do I have to go to the city and give them my name and give them the name of everybody who I'm going to designate as a circulator in advance? Because that wasn't on here before.
Well, I've been involved in
Oh,
about
yes.
a dozen
Yes,
of
it
these
was.
initiatives and referendums around the state. And in every city and county that I've worked with in these types of cases, you have to go in and you fill out the petitioner's committee form, and you have to have your petition. It gets circulated. Some cities require like a notary for every signature. Other cities.
Yeah, I know after the fact, fine.
This
I mean,
particular city had a petition that went around, and apparently the prior city attorney had an opinion that only the person who was on the form could collect
Who was the
signatures.
circulator?
Yeah, only that person, and there were many, the person had other people, other citizens go collect signatures as well, and those were all disqualified or thrown out because they weren't listed as circulators, or there was no requirement. The current charter didn't say anything except
why does my circulator have to
So,
be a
Helen,
registered voter
can
in the city?
I refer you to 13.3, section 13.3, petitioner, and then paragraph C. It actually has in our original charter, affidavit of circulator.
Okay, not on this. This isn't
Right,
the whole.
but there was affidavit of circulator, and it
that
it
still
was-
would be required.
Right, and it's not something that's been added. We cleaned it up because, again, it was ambiguous to how it could be done, who was the circulator, who was the petitioner, what had to be filled out. So we're not creating a step. I don't know if it's even something in the state statute, but this is in our original charter, that you do have to do these steps in order to circulate the petition, and how then you certified by affidavit that, yes, I went out and and I saw these people sign.
Got it.
Okay. And then,
What-
if I understand, then that, of course, then goes to the supervisor of elections, and those people's signatures are certified that they are, in fact, registered voters, et cetera.
What was the rationale for making anyone who collects a signature also be a voter in Madeira Beach? Why can't I get my niece to help me collect the signatures, who doesn't live here? I mean,
I think the commission just wanted to make sure that the political process was for the citizens of Madeira Beach, and there weren't people coming in from Miami or coming from Tampa to propose an ordinance here.
A
That it
paid
should be coming from
circulator.
our own citizens, you know. I don't want to use Miami, but I'd say a Miami developer wanted to come in here and wanted to put up a high-rise tower and said, I'm going to go collect the signatures, and started doing it. Someone from outside the city that wasn't coming from the citizens itself. This is more of a citizens initiative, as citizens of Madeira Beach. And I think that also I think they wanted to make sure that the people actually had a vested interest who were circulating, that they weren't simply doing it because they're getting paid. There's a number of paid circulators that are doing state constitutional changes. When people approach you sometimes at the library with a clipboard, some of those are not volunteers. Some of them are getting paid per signature. So this is making sure that at least the circulators did actually live and were voters here.
Okay. Well, if I only need 330 signatures, maybe I can get another voter to help me, but, okay, thanks.
And that brings, one more question? Go ahead.
Just one more state. So this was brought up because the previous petition, the people failed to get the proper information on how to do it. So rather than learn how to do it the correct way, let's just change it.
Well, I think-
Absolutely not.
I think they tried to.
Isn't that what was just said?
No, they tried to
No,
do
it
it
was
correctly
not.
by following what was in the existing charter, and it seemed that they did, but for some reason, there was a difference of interpretation by the prior city attorney. So he knocked out the petition before it could
Correct.
ever go to the ballot. But if you looked at it, it was pretty ambiguous. So what they're trying to do now is clarify. So if a citizen reads this, the citizen can understand what has to be done.
Okay.
I have to go fill out the form, get the petitioners committee, list my circulators. They should also be registered voters. There should be 10%, and that's how they would go about doing it.
Okay, now, so for the registered voters, then that form is going to have for each circulator, they're going to have to put their voter registration number in there?
No, I believe
It's
it
just
only
word of mouth,
calls-
you're just going to believe I'm a registered voter? Okay.
No, the
Supervisor of elections verifies all the signatures, including the circulator who signs the affidavit, as well as the people who are signing the petition, to make sure that they are registered voters at that address and their signature matches. And typically, sometimes they'll knock out a number of signatures, a certain percentage won't make it, either
Okay.
because their signatures don't match or they're not currently a registered voter.
Okay, just want to clarify the process before we move forward. Thank you.
I think that brings us to the end of the charter questions, unless there's any general questions. Thank you very much for coming this evening to learn about our charter amendment process. Thank you.